While reviewing a contract between you and your vendor is anything but gripping, it has to be done. Why is that? Because sometimes there are landmines placed all over them. My guest today is a healthcare attorney who helps his clients negotiate fair agreements among his other services, and he's going to share some of the landmines that he finds and what you can do about it. I'm Carl White, principal at Mark Advisory Group, which is a healthcare marketing agency, and I'm also the host of Practice Care. The mission for both is the same, and that's to help private practice owners stay private. Usually that's what they want anyway, but care is better. Everything can be better when the provider owns the practice. They can make the clinical decisions they think are best. They can make the scheduling decisions they think are best. Anything that they think is important, they run the show so they can make those decisions. It's just not always the same when somebody else owns the practice. Their scheduling decisions come in, their agenda starts to creep in. It just happens. Let's keep it simple and let's keep it private. My guest today is E.J. Cyran. E.J. has spent over a decade as a healthcare attorney, which means he represents physicians, dentists, and their practices in negotiating vendor agreements, buying or selling their practice, handling associate buy-ins, and getting advice on their regulatory and payer issues. He knows his way around HIPAA, telehealth, Medicare, and all other matters affecting healthcare practices. E.J. is definitely a go-to lawyer for his clients. E.J., thanks for coming on Practice Care.
My pleasure, Carl. It's great to be here.
It's good to see you. It's good to see you again. We've known each other now for a little while. And these are topics I really like. They're very practical, very useful, very nuts and bolts. Every listener is going to walk away with something practical you can do. You're probably going to open our eyes on something shocking that's buried in legal lingo. So looking forward to that. Regular listeners know we're going to have one question before we get to the topic, and that was a short bio I just read, but that's what I asked for. So fill in some of the gaps. Help us get to know you a bit better.
Yeah, thanks, Carl. Again, my name is E.J. Cyran. I'm a partner at Fox Rothschild LLP. We are a national law firm. We're based out of Philadelphia on the East Coast, but we have 30 offices in 20 states. And as a healthcare lawyer, I represent clients around the country. We represent the full spectrum of healthcare providers. So medical, dental, veterinary practices, therapy practices, all types of clinics, and then lots of different types of healthcare facilities. There are many of those. Everybody always thinks of the hospitals, but there really are a lot of them out there. And so I get experience with a lot of different aspects of the provider world, the challenges they face, of course, the healthcare laws and regulations that apply to them, but the insurance payer issues that they have, and then all the business issues that they have because we serve as their outside general counsel.
So do you get involved with fighting insurance companies?
On overpayment appeals, enrollment issues, absolutely.
That's got to be the slowest battle. I don't know what the slowest battle that you face is. None of them are probably terribly fast, but I got to imagine that's amongst the slowest moving.
It is. I actually had one physician client who had to wait 6 years to have his Medicare overpayment appeal heard by an administrative law judge, and we were successful. But it took 6 years.
Oh my God. All right. A topic for another episode. So we're talking about landmines in vendor agreements. I have faced some of this. None of the landmines have ever exploded, but you sort of read them and go, wow, okay. So a fairly obvious question to get us started. Why do vendors sometimes do this? Why aren't there fair, balanced agreements? Both sides have some risk, both sides have some reward, feels about even. There's all sorts of skewing going on. Why do they do this?
Yes, it's
like, what kind of relationship can you have if there's landmines planted in front of your feet, you know?
Well, right. It's a business relationship first, right? So there's a sales representative that the physician or the practice manager of the practice will be interacting with. And that sales rep is not the person who's writing the contract, right?
Yeah.
Or wrote the contract template, you know? So they are expecting that their clients, by and large, won't read the agreement or will only look at the very basic business terms like the fees, maybe the services. They're probably just going to look at the proposal that might be given by the sales rep, and then they just sign the agreement, right? So if that's their client base, by and large, why not draft this agreement to be one-sided if you're the vendor in favor of you?
Interesting. So it's just, they do this because they can.
They do it because they can.
I kind of expect you to say something like they do it because they want to protect themselves. They really want to make sure that they're protected should it hit the fan.
Right.
Yeah.
It does certainly protect them.
Yeah.
It's very one-sided, but it's so one-sided and not even close to the middle and the way it should be if it were negotiated. And that's because of the clientele.
Right. So they do it to protect themselves. They get away with it because nobody ever looks.
Exactly.
Yeah. So there's a variety of types of vendor agreements. Which ones, I imagine there's some that pose bigger risks than others. Which ones do you see are like the real kind of big risks? What types of vendor agreements are they? Tell us about them.
Yeah, I mean, I think they break down into two general agreements most commonly.
Hmm.
One is a billing company agreement for billing services. So they're going to process your claims. They have heavy access into your EMR system,
Mm.
and they're the gatekeeper basically for you getting your claims reimbursed.
Hmm.
It's your only source of revenue, so very important.
Hmm.
And two, SaaS agreements or software as a service agreements, SaaS, and that category is huge, right? That's a lot of different types of software providers.
Okay.
And that's really, most people would say it's a subset of services agreements in general. So there can be some other types of services, right? But I think that software is the most common nowadays. But certainly, there are some staffing services agreements. But I would say SaaS agreements and billing company agreements are the most frequent ones that we see. Another way to think about it is any agreement where there is a business associate agreement attached, right? Any
Hmm.
service agreement that also has a BAA, is a vendor agreement of
Yeah.
some sort and really needs to be negotiated and reviewed by knowledgeable counsel.
Okay. And so when it's just some examples of SaaS, so your EMR, your email, would you put your Microsoft Office, would you put all those in that bucket?
I wouldn't put the Microsoft Office licenses in there, but certainly EMR.
Okay.
And I found that there are a lot of software providers, that want to hook into your EMR system for a
Mm.
variety of different ancillary type services that will
Hmm.
make, practice management easier or personnel issues easier or create a patient portal or
Hmm.
additional modules on the patient portal, right? And that is just very attractive to a lot of different specialties, a lot of different
Yeah.
physicians. They all have their reasons why or interests that they have in expanding their practice for their particular patients. So there really are a wide variety of different software products out there, and they come in when it's time to get down to the contract. It's the same kind of agreement, and that's why we call it a SaaS agreement, software as a service agreement, because it's not like the old days where you get a CD-ROM in the mail and install it. This is a software that's being provided on a subscription-based
Hmm.
platform, and it's through the internet.
Right. Okay. And let's get into some of the, I want to come back to the BAA part because
Mhm.
um, I guess it's another type of agreement. Let's get into some of the landmines themselves. Like, I guess let's
Yeah.
pick the SaaS agreement ones because you're saying that's probably the biggest bucket. So I'm imagining it's this long list, but if there's a few like, to kind of open our eyes.
Yeah, I think that they break down into a few really key categories. Obviously, from a business perspective, you need to know that the fees that they promised you, the services that they promised you are written out. They're usually in a schedule. Sometimes, like I mentioned, they're in what's called a proposal, which really isn't a contract itself, but could be depending on how it's written.
Hmm.
If so, there's usually like a separate terms of service that is attached to it. It
Hmm.
seems like it's non-negotiable. And those can get really dangerous because they're also really difficult to read. They're like the smallest possible font. you know. um, but the general issues that we're going to talk about come down to several risks. One of them is the difficulty to get out of the agreement without paying some sort of early termination fee, not having recourse at all or having very limited recourse when there's a breach by the vendor of their obligations on the agreement or a breach of the business associate agreement because they had unauthorized disclosure or use of protected health information. The fact that, if there's an issue with this vendor, you lose that service. And if that service is a billing company service, for example, that's a major problem for you,
Hmm.
practically speaking, until you find a substitute. Same thing goes with certain types of software as well. Um, and then, if it's billing related, could you end up having overpayments assessed to you by payers as a result of mistakes made by the billing company in the claim submission process or
Hmm.
delays in that process? So those are just at a higher level, very big issues that arise from these agreements. They're landmines, if you will.
Hmm.
And then I can elaborate on them here because I think it's
Yeah,
helpful. I don't want to get too much into the weeds, of course.
sure.
but I do think it's helpful to really
Some weeds
articulate.
help, so go ahead. Yeah,
Sometimes they do,
they
right?
do. Yeah, because it's what I mean, for you, this is your first or second language. For the rest of us, it's not. So,
Right.
A little more explanation is fine.
Sure. So let's start with those early termination fees. And this is something that the sales rep isn't going to mention, right? But they're usually tied to some sort of length of the term of the contract. So, instead of this being a 1 year annually renewing contract, it might be a 3 year contract or a 4 year contract, 5 years, 2 years, something like that. And if you are within that contract term as the practice, the vendor doesn't want you getting out of that contract. They want you paying them, right? So as the practice, there's an issue. You end up having, and you need to terminate this agreement because you can't deal with this provider anymore. You have to pay some sort of early termination fee.
Yeah.
And this could be very simple in calculation. They could just say, you owe us this fixed amount. They could say that you owe us the subscription fees that you'd otherwise pay us for the rest of the term, right? It's certainly, it isn't fair if the month before the term, the 2 year, 3 year term's over, and they've completely breached the agreement and you terminated, that you would have to pay for the entire 2 or 3 year period. It should be prorated. The biggest thing with this is that it's commonly hidden, right?
Can I just ask so does the reason why you want to leave factor into how much you might pay? Like you just said, like I was thinking, all right, I changed my mind, I want to go, I should owe a lot. But if you reached, you screwed up, shouldn't that matter? I guess maybe not.
It should, and the agreement typically will not address it that way. Okay. And the response that you would get from the vendor is, well, you shouldn't be able to walk away, right? You're committing to work with us, and we need you to commit because we're going to spend time training, and this is you're an important client to us. Depending on the size of the business, the vendor, you might be one of 25, 30 clients for them, right? So it could be 1,000, right, too. But there's a wide variety of different software companies like this, or billing companies. And so if you were to leave, they lose out on revenue that they plan to have, since it's a subscription-based service, right? So, or a monthly service fee for the billing company, right? So it's a big deal for them, and they want some recompense in the event that you back out. But at the same time, like you said, if they violated the contract, or they have repeated issues that are end up material to you, and you really just need to move on because you're paying for something that's not worth what you're paying for, you should have the ability to get out of it. And that has to be written into the contract, right? You need a knowledgeable lawyer who can write that kind of provision of the contract, because it's not going to be in there at all. Instead, it's just going to say, you owe us X amount of money. Again, could be fixed fee, could be based on the amount of months left in the term. But it's not, in any event, it's definitely something that is in most of these agreements, and is difficult to find because it's not going to be a little provision that says early termination fee. You're lucky if it's that easy to see. It's very often in the term section, or in the termination section, or in others. The fee section, sometimes just about the general fees, where you're usually looking at a schedule. You forget to go back and look at that provision agreement because you're looking at the schedule where all the business terms for the fees are that you've been speaking about with sales rep. So that's a major issue, and it's hard to get out of that fee as well. And it can be a lot of money. It can be tens of thousands of dollars we've dealt with before, and you end up trying to negotiate with the other side. So that's the first category. Second, limitation of liability, and this takes different forms, but it's a hallmark of a vendor agreement, with the idea being that these vendors have a lot of clients, right? Or even if they don't, it's not their business model. They have to be responsible for liabilities of their clients. But, in reality, that's not really, from our perspective as the practice, what matters. What matters is that they give us what we pay for, right? And we're not asking them to be responsible for our liabilities. We're asking, as much as we're really asking for them to be responsible for their own failures, right? So should they really be limited in their liability? I don't know. I mean, their argument is, well, they wouldn't be able to survive if they had some sort of major event, like a breach of technical health information or ransomware attack, right? They why should they have to pay for all their clients? Well, because you're in the business of dealing with
Yeah,
this
like I wouldn't even occur to me to
important
say,
information.
let's just
Yeah.
let's collect sensitive data all day long and just kind of leave the door open. I would think you'd want to lock that puppy up pretty tightly and
Right.
not be held accountable if somebody walks through an open door. That's interesting. Okay.
Yeah. So how can liability be limited for these vendors? So it can be limited in the amount of the damages, right? And the type of the damages. So from an amount perspective, it could be a certain number of months, right? The last 6 months of
Mhm.
fees that the practice paid would be the maximum amount in dollars that the vendor would be responsible to the practice. There could be just some general cap to that. And then from a type perspective, this gets a little bit confusing for clients, I'll tell you a little story about this as well. Typically, the type of damages are limited to just what are called direct damages, meaning, a prorated portion of the fees you've paid to date, maybe the cost of buying an alternative software, or maybe to some degree paying an alternative billing company. But direct damages in the legal world, they can't vary much, right? And as long as there's some sort of intervening force, it jumps out of that category. And the rest of the damages, they block. The rest of them, they limit. So things like the lost profits you incur, right? The personnel costs or other costs you incur in trying to find a replacement. These are what are called incidental or consequential damages, if you see them in the agreement. Punitive damages, like if the vendor's reckless or grossly negligent in how they do their job. And so that leads me into the story. That's a classic one that's blocked, right? So I had a small practice, solo practitioner, who went with a preferred vendor of Athena. So Athena was his EMR system,
Mhm.
and he was directed to this preferred billing vendor. And he was with them for about 2.5 years. But from the beginning, there were problems within a month or two of when they started.
Wow.
And he was sold a bill of goods, right, by the sales rep. Oh, we can do this for you. We can do that for you. He had a few unique types of billing situations, and gathering information for the claims was a bit unique in his case. But still, we'll do all this for you. We'll also credential for you. These billing companies are typically credentialing services as well. So remember, credentialing. You have a nurse practitioner. They need to be credentialed with all the payers. Until they are, you have to hold the claims for all the services they're doing.
Yeah.
And that means you have no revenue for that, and you're paying their compensation. Well, this company had every possible problem, this billing company, with providing their services, including with the credentialing. And so months and months go by. And my client he wasn't my client at the time, but this is what happened with him. He did what you would think would be, honorable. He and his practice manager were constantly emailing the billing company, hey, you didn't get this done. We're seeing that there's a problem here. And they're spending a lot of time looking at their own records saying, hey, these claims are messed up. They have the wrong information. These are going to get rejected. They have been rejected.
Mhm.
We've been waiting on these for 6 months. You name it. They had all these problems, and they tried to work with that billing company. So what happens is, after 2 years of this, they get so tired of it, and they've lost out on money, et cetera, that they give up, and they terminate the agreement. And the billing company does the same thing back to them in retaliation to try to get some sort of legal upper hand if they can, saying that the practice breached the agreement as well and didn't pay them everything they were supposed to be paid to get all this, right?
How long was the agreement? So this was 2 years in. How long was the agreement?
I believe it was a 3-year agreement.
Okay.
Yeah. So our client comes to us and wants to litigate this, and he keeps talking about how they were so negligent. Shouldn't they be liable for that? And I had to explain to him that it's a contract, right? This isn't what in the tort world, like personal injury or something like that. If somebody's negligent and they cause you damage, that's legally recoverable. But in the contract world, whether you're negligent in performing something that's not enforceable against them. It's what the contract says, right? Did they perform the services they said they were going to perform? And sometimes there's a reasonableness element to it, but it isn't as simple as, man, they were really difficult to deal with, and I lost all this money and all this time as a result of it. He had a
Well, can I
limitation
just ask a question?
liability.
Because
Yeah.
Because you said, did they perform the services they were supposed to perform? My head went to, sounds like they didn't, because there was rejections, there was delays, that doesn't
Right.
sound like services being performed.
It doesn't, but they did.
Oh, Carl, you're just a silly non-contract,
This is what happened. So it's a good segue to the end of the story here.
Okay.
Is what they did was the billing company actually first hired a lawyer who didn't know what he was doing on their side, and within a couple of months they switched. They switched to a specialist out of Chicago who was probably getting paid $1,000 an hour or more, something crazy high.
Mhm.
And this guy's job was based, he defends billing companies, and he was just going to shut this down.
Mhm.
And so he forced us in representing the practice to spend all the time and energy, although we didn't start this way, we tried our best with some letters and correspondence. He forced us to go through the emails and lay it all out, lay out our case against them. And then they came back and they had emails for different arguments that they were going to, that they tried to misdirect on. And the point is, at the end of the day, is our client spent about $10,000 in fees, which isn't actually that much because we kept it under control for him out of respect for him. And that's how I handle my clients. Not every law firm's going to do that, by the way, for a practice. They could have spent $25,000 or $30,000, and the result is the same, zero. Because on the other side, they're willing to pay their law firm, the billing company, instead of paying this practice anything at all.
Right.
Right. So they weren't willing to settle, and that's unfortunately the case. Often, especially if the vendor gets, a smart litigator on their side. They've since not, they've lost their preferred status with Athena.
I would hope so. I was going to ask.
But it illustrates how difficult it is, even when you know you're in the right, how difficult it is to recover anything from them. Because the truth is, you're never going to go through trial anyway, right?
Mhm.
Trial takes, no matter who you hire as your counsel, trial is going to be over $100,000 to do.
Mhm.
Right? Probably more. In this case, there was a mediation required, and then venue was going to be in Boston, and the mediation had to be in Boston, even though these parties were in Pennsylvania and in Chicago. So it just didn't even make any sense. Like it just, you run into all these hurdles in these kinds of agreements. The limitation of liability was there for all the credentialing services, at least. It makes it extremely difficult, and you're just not going to spend the legal fees to pursue them when you don't have, a reasonable chance of success. So that's the danger at the end of this process. What could have been avoided early on, he could have had a knowledgeable attorney review that contract and negotiated a whole bunch of provisions, like the limitation of liability, but others too, to try to force them to address the specific things that he wanted them to do. And try to provide some sort of service levels in there. That's another important point I wanted to bring up is service levels, because they're sometimes called SLAs, or service level agreements, but they're really not agreements. They're provisions in an agreement. And they set the direct obligations for what the vendor is going to provide at a certain service level. And if they don't meet that service level, then they can be liable, right?
So like, what's an example? Like 90% of your claims will be filed within 30 days, or so, like a level of service. What do you mean by that?
That's an example in the billing context. It could also be it's very often in the software context, this concept of downtime, right? If this software is a module for your patient portal, but it's down 50% of the month, should you have to pay the full fee, right?
Yeah.
And unfortunately, again, these are very one-sided in how they're typically worded, but they can be negotiated, right? So typically they're going to say something effective, well, you just won't have to pay us to fix our own software. Okay, great, thanks.
That's so generous of you.
We're willing to fix your own software, right?
Yeah.
But what about the fact that it was down, and that affected my practice, affected my patients, whatever it is. There is a need to negotiate that kind of provision, because the other reason is it's the way out, right? It's again what we were talking about at the beginning. If this is not a good match for you because this vendor doesn't have a good service, they're not doing a great job administering it, whatever the issue is, why should you continue to have to pay them month after month and stay with that contract, right?
Yeah. And
this is the way out. And why should this be limited, right? It shouldn't be, oh, you have to give us every chance to fix this. No, it should be, if you failed once, twice, whatever, maybe there's a repetition term to it, but once it happens a certain number of times, whatever the threshold is, you should be able to get out, right?
Yeah.
You should have to get that early termination.
Yeah. It's interesting. You were talking in this story. I started to think, I wonder what the vendor spent more money on or would have the legal fees to fight it, or if they just paid the claims, whatever was owed. And the answer is, to anybody listening, including me, it doesn't matter because they chose to fight. They might have spent more money. Who knows? But that's the
Right.
choice they made. It's probably the choice your vendors are going to make if it gets to that point. So it doesn't sound like there's any reason, common sense, or I don't know. I don't want to say ethics. I don't know what the right word is, but they're going to fight, and all of a sudden you're a jerk and you're the enemy, like in a day, even if it's, expensive litigators out of Chicago or wherever, you're now the enemy. So,
and another reason why they'll fight is to set a precedent, or
yeah.
in other words, to not set a bad precedent, right?
Mm-hmm.
But set a good precedent. So if you go talking, and this is of course more common nowadays, where you have forums, where customers of a vendor might, communicate about support issues, or Yelp or whatever, or Google reviews, right?
Mm-hmm.
They don't want their clients to be talking about the fact that they were able to settle, with the vendor. That might be protected by confidentiality. That's a major risk. They don't want that precedent out there, because then that theoretically could open the floodgates for them if they're bad at what they're doing. They could have a lot of clients who are
But the
emboldened.
opposite is, I 1-star review. They failed, and then fought on very common sense things.
Right.
Stay away from them. I guess they must be picking that too.
Yeah, it's a fine line they got to walk, but
yeah, but they choose
what,
it. So
how they view the risk.
you mentioned a number of times negotiate with them. I have to tell you, obviously, yes, that's what you do. You negotiate, but let's use your single doc practice, the story that you gave. I'll use myself. There's a number of SaaS services that I use, and I think, why the hell? Maybe I just talk myself out of it. Why would they negotiate with me? I'm one. What kind of power do I have? How would I get them to the table? Why would they sit at the table metaphorically to negotiate? They need standardized contracts. If they had different terms for everybody, holy cow, it would blow them up. That's a reason why they don't. So you can actually do this. Like, how do you get them to change that term to what you want when you're an individual,
Like in
client?
any contract negotiation, do you have leverage? That's the point you're hitting on, right? What is your leverage? Are you a significant, meaningful client to them or not, right? If you're talking about a billing company like this was, yeah, they were preferred vendor for Athena. I don't know how many, there are a number of many different billing companies that preferred vendors of Athena. I don't know how many clients they really had. They were not a big company though, for sure. They did not have a lot of personnel and staff, and they had a lot of turnover too. So that
did you find all this out as you were digging into this?
Yeah,
it just sounds like a, forgive me, like a shit show behind the scenes.
Yeah, right.
Like, oh my God.
But Athena supported them, right?
Well, and there's and then, Athena, what kind of due diligence are you really doing? Like, your name's on this recommendation. Does anybody even bother to look? So yeah, anyway, keep going, negotiate.
So yeah, what's the leverage that you have is one point. But another point is you have other options, right? Yeah. So if you try to negotiate and they say no, move on.
Yeah.
Right. And that could have easily happened here, right? He could have just gone to a different provider, a different billing company, and that would have been a better situation for sure. Because this was, again, one of those, because it was recommended by an EMR company, there was a standard terms of service, right, that was attached to a proposal. It was very difficult for him to interpret, that had a bizarre venue provision in Boston, that had really strong limitation liability, because Athena wrote that to protect Athena as well as this preferred vendor.
Oh, wow. And did he kind of read through this himself? Like maybe him and his practice manager?
Yeah, I don't even think he did. Yeah.
Well, did he have an attorney? Like, did he have a bad attorney?
No, he did not.
He had no attorney. Right, so he was doing it himself. Okay.
Yeah, and he really just read through the proposal, right? And so sometimes the other thing we can do in those kinds of situations, because you got this, fine print, long-term to service, what we can do is, we can write what we need to write in the proposal piece, if you will, or the schedule or the exhibit that's attached to it that's special to you. Because you're right, and that vendors typically will say, well, we don't negotiate those standard terms. Okay, well, we won't touch that piece of paper. Don't touch that document. It is what it is. But we have an exhibit here, which of course has specifics about our fees and everything else. And that will control over those standard terms. It's normally how those exhibits are set up.
The exhibit takes precedence over the standards.
It can, yeah. I mean, and so that's where sometimes they'll allow for certain provisions in there too. Have a little section where maybe you could add in some things that are specific. So yeah, that's how you do it, and not be as like, you're not blowing up this document that is carefully drafted by their counsel. You're just adding a notwithstanding anything to the contrary up at the front, to allow you those certain exit rights, for example. So one other thing I wanted to mention about the landmines is the associate agreements.
Let's get back to the business. Yes, please.
Breach of protected health information, because it's obviously a very serious issue for practices. It's not as much of an issue in other businesses, right, in other industries, but in healthcare, it's a major, major issue. And these vendors who are giving you the service agreement will often try to give you their own business associate agreement. And they sell it as, well, this is a standard business associate agreement, And what they mean is, what they mean is that it's a minimum level business associate agreement as required by HIPAA, right? And so HIPAA has actual provisions. It says these provisions need to be in the business associate agreement. So that's legally the only provisions that are required. And so over time, the Office for Civil Rights that enforces HIPAA actually issued a set of draft provisions themselves that you could just take and create a business associate agreement document directly from. And so that's often what these look like. But those provisions, unfortunately, are just bare bones and really weren't intended to protect the covered entity under HIPAA, which is the practice.
Yeah.
They were really just intended to ensure that the business associate disposes of the information at the end of the term in a compliant manner, those kinds of very basic things, that they would turn over documents they have to OCR in the event of an investigation, but not the kind of stuff that we're talking about here. And so what happens? The limitation liability provision that's in the service agreement that we just talked about applies to this, right? It applies to breaches of protected health information. And so, ransomware attacks, which are more and more common every day, when one of those happens, we're told by the Office for Civil Rights that enforces HIPAA that you cannot make an argument that your protected health information, because the protected health information belongs to the practice, that has not been breached, right? You can't make that argument because it's a ransomware attack and we just don't know what that hacker actually did with that information while it was held, right, in ransom. So even though they say, the hacker says that they returned it, right, and they do actually return it in most cases so that they don't set a bad precedent for ransom being paid. Some of them, they could have copied it.
Yeah, I mean, doesn't breach just mean you broke in and took the stuff? It doesn't mean you did something bad with it. Like the breach, isn't that what breach means?
Right, I know. Well,
you can't prove they breached, but they took it. How else would they get it unless they reached the front door? Like, really?
Yeah, well, the idea that what the ransomware attackers say is, well, we're holding it. And if you pay us, we won't release it.
We breached your services to grab it, and now we're holding it. So that part, the first part gets overlooked.
Yeah.
Okay.
Well, at least some attorneys tried to make those arguments for practices that had this happen to them. And so the Office of Civil Rights came out and gave guidance that, they are going to view that as a breach, and you cannot make the argument that's low probability that PHI wasn't compromised. Mm-hmm. So you have to, you're in a position, where if there's a ransomware attack, which is usually the most common, phishing is also common, then you have a breach. And when you have a breach, you have notification requirements as a practice. The business associate, and this is another thing that people get confused about, the business associate does not have, under the agreement or otherwise, obligations to notify patients.
No.
It's the practice that has the obligation. So now you're going to have notification costs, right? You have to send out however many it is, and usually in a ransomware attack, you're talking about all your PHI, so all your patients, former patients, right? You're going to have to send out notifications to them about this breach. And once you hit 500, in number, you also have to notify the media and you have to immediately notify the OCR. Otherwise, you'll notify the OCR at the end of the year in your annual breach log, in which they can investigate too. In either case, once they find out, they can investigate. When they investigate, they can issue fines. And often people get confused about that and think, well, maybe I won't get fined for what happened here. What could I have done differently? Well, it wasn't my fault. It was the business associate's fault. They may choose to not fine you and refrain from doing that based on circumstances with the incident. But what happens is that they often do fine, because what they do is they ask you for everything. They ask you for your HIPAA policies and procedures. They ask for proof of training and how you've been implementing those policies and procedures, as well as information on the incident. And what they find is a lot of the practices don't have their policies and procedures properly prepared, or they're not following them in the way that they said. And that maybe in this case, their failure to follow it led to an issue related to the incident. But in any event, those fines often do occur, and they don't have to be substantial, but they can be. And sometimes the OCR wants to make an example out of a small practice, right? So that they can publicize it.
Yeah.
Not the name of the practice, but what happened,
Yeah.
right? So that others know how important it is to protect against this particular issue. So
I saw a report of a fine, a low six-figure, but six-figure fine. Let's say it was a dermatology practice. It doesn't matter. Simply because they didn't have BAAs in place. Nothing bad happened, but it must have been an audit, or it must have been somehow they said, let's go visit them. And yeah, six figures simply for not BAAs.
right.
Yeah, no breach, no nothing. Just make it in place. Yeah.
Right. So there's a lot of potential there. You don't want the spotlight turned on you
Mm-mm.
as a practice, right? So a breach of protected health information by your business associate is something that is a major risk, especially when the business associate uses other vendors.
Mhm.
And this is very common. They use subcontractors. Sometimes they use subcontractors overseas, which is very common, especially with billing companies.
Mhm.
They'll use a company in Asia to go through these claims or whatever, and so they're transferring protected health information overseas. You can bet there's no way there's going to be an argument that that information wasn't compromised.
Mhm.
And so what happens in those situations is you need recompense, you need recourse against the business associate, or you're stuck with all the costs. You're stuck with the legal fees for dealing with the investigation, responding to the OCR and things like that, as well as the notification, remediating the situation. You're stuck with all those costs, and it's really not your fault, right? So what can we do in the business associate?
But you know what's funny is I can picture myself, maybe justifiably or not. Let's say my doctor did that, and they're getting billing overseas. I can imagine myself looking at the doctor and at least saying to myself, how did you not know where your data was going? I mean, how could you? Where's the data being I don't know. Like, how do you allow yourself? And I'll bet you in my business, I've got somebody could and say, and I'd have to answer, you know what, I don't know. So it's not fair, but my God, this is
well, HIPAA doesn't require, and the regulations do not require protected health information to be kept within the boundaries of the United States. So business associates.
Well, so like, how did you not know? How did you not make sure that they were, compliant with? I guess.
Oftentimes, the sales rep won't be saying anything about that.
And you know what? 99 out of every 100 don't even think to ask. So we're a HIPAA compliant healthcare marketing agency. I've had two of my clients in my 7 years of business life say, yes, I have a business associate agreement that you need to sign. The rest did not. Of the two, one gave me an agreement that was dated 2013, which was 3 years before the massive high-tech overhaul of HIPAA. So it was out of date. The other one downloaded the template from Health and Human Services that you mentioned. Inside the template, listeners, are suggestions and comments from HHS to you to say, you might want to tailor this paragraph this way. They left it all in. They didn't even bother to take that out. The rest, I had a BAA drawn up. And I'd like to think it's more fair and balanced than all the ones I've had to sign and all the other ones I've seen, because nobody else had them, and so I'm prepared to sign to anybody's, but do you have a BAA you want me to sign? Otherwise we're using mine. No, just send me yours over and over again. So,
and this is especially mid-sized practices and larger, it's very, very common to have your own practice business associate agreement and demand that your vendors use it. And typically they do get traction with that. Now there's
Mhm.
probably going to be negotiation with it, but they do get traction with a lot of those vendors.
Mhm.
Not everyone. The largest vendors, not. I mean, you can't argue with Google,
Yeah.
Amazon, negotiate with them. But the truth is, you're going to have a heck of a lot more security usually with them and
Yeah.
those size vendors.
Yeah.
But it's the smaller ones you got to watch out for. The ones with the new idea for a service for your patients, a new product, and you think it's going to make you some extra money or whatever. Those are the ones who really don't know what they're doing from a security standpoint, and they are going to toss this basic business associate agreement at you and say sign it, and then they're probably going to say, oh yeah, we can't negotiate yours, we'd have to hire a lawyer and we can't, there are a lot of
Yeah.
companies like that out there that are basically startup companies in a
Yeah.
way.
Yeah.
A few stages graduate from that. So what you can do is you can make the business associate responsible in two ways. One, with an indemnification provision, that they'll indemnify you for the fines, right? The third party liabilities you have against you if a patient tries to sue you under some state protected health information or personal information law, they'll indemnify you for that. There is no private right of action under HIPAA, so a patient can't sue you under HIPAA specifically, but you can of course be fined, right? And then the other thing is that you can cap. I'm sorry, not cap, but you can create a reimbursement element to the agreement so that the business associate is responsible for reimbursing you for the expenses you incur. Maybe they negotiate a cap on that, but the expenses that you incur in notifying the patients, in hiring a lawyer to do an assessment for you and respond to the Office for Civil Rights, right? So, you have a direct reimbursement obligation, but then there's also that indemnification obligation as well. And then you got to make sure that those two are not limited by the limitation liability provision in the services agreement.
Mm.
Or maybe if it's a vendor BA, that there's not a similar limitation liability provision in the BAA.
Right.
If you don't do that, it's really not worth much, because remember, you're going to be limited to amount of damage, like 6 months of the that you paid in fees. That's not a lot of money usually.
Not to cover this type of
not to
example we're
cover
talking.
this.
Yeah.
Right.
Cool. Interesting. Yeah, interesting. I mean, God, BAs, we could have a whole separate episode on that one.
We certainly can.
But I'll just say, please, practice owners out there, get yourself one. You need it anyway. HIPAA, the HIPAA says you're supposed to have it. It needs to be in place. There's all sorts of risk that's easy to get rid of if you have one, in any event. So, a couple of wrap-up questions I ask every guest. The first one is, we covered a lot of ground here, but is there anything you think we should have touched on we just didn't get to?
I would say cyber insurance, and how it can help in this situation, specifically at the breach of protected health information. Cyber insurance has been growing and developing as an industry. From what I hear from those brokers who are involved in the earliest stages, it really was not much coverage at all of anything. Now there still are a lot of options for cyber insurance that don't really cover much. Sometimes you see them as endorsements on malpractice policies. Those are probably not going to give you much of anything from a coverage standpoint. There are like I think it's 3 or 4 big carriers who really specialize in cyber insurance policies. They're the most expensive premiums, but they also offer the best coverage. And if you had a breach, it would certainly cover that. But a big question is whether or not your policy will also cover a breach by a business associate, right? And what the conditions on that coverage would be if it does cover a breach by a business associate. Does it cover a subcontractor who's in Asia, right, or Europe, right? Or is it limited only to that one in the United States? Where is the line drawn for that?
Yeah,
it's really important, and those policies can get really complicated. So it's important to have a knowledgeable insurance broker on cyber insurance to help you navigate that.
yeah.
But you have to expect that that's not always going to cover you in these instances. And the other thing is that it can get expensive, and it can be expensive based on the limits. So, you think you might get $1 million per incident, but you're probably not going to have more than one incident a year. So the cover, 1 million, 3 million, you're not going to have 3 incidents a year, most likely. You're going to have one, and you're going to have $1 million worth of coverage. Is that enough? It depends. I don't know. Maybe it is, maybe it's not. That includes.
It's what makes it hard. You're like, well, how much coverage you want? I don't know.
Yeah.
I don't really none, but I have to pick something. How the hell
Right.
do I even, you know, guesstimate? Anyway, yeah,
And insurance
that one.
companies are in the provision of, or in the business of denying coverage,
Then
right,
there's
based on
that. Yeah.
circumstances, right? So they're not in the business of just paying out every claim that's made, for them.
Yeah.
So it's really it's important to have, but I would say that actually what's even more important to have, perhaps, in these vendor arrangements is that the vendor has an insurance requirement for cyber insurance, that they prove to you that they have that
Mhm.
insurance, and that you can get out of the contract without paying the early termination fee if they lose that insurance,
Mhm.
right? Or they don't maintain those limits. Um, because ideally, you would even be an additional insured under their policy. But even if you can't, if as long as they have cyber insurance, then at least if they have a breach, there's a high likelihood they're going to have some money coming in the door, and
Mhm.
you're not stuck suing them without them having
Yeah.
any funds. You
Right.
can't get blood from a stone, right? So you got, and plus remember, if they have a breach, it's probably not just going to be with your information, but all their clients, right? So they have a
Mm.
lot of clients who are trying to sue them.
Mhm.
They should have high enough coverage so that you have some money accessible in the event
Fair enough.
it happens.
Yeah. The other wrap-up question I ask is, all right, I'll say we've caught a listener's attention or we've scared the crap out of a listener one way or the other. And they're like, you know
Right.
what? I don't know anything about this. I should look at this. What's a simple place where they can start? Just to start to wrap their heads and make their
The best place,
situation knowledgeable and
yeah.
better for them.
Well, number one, read the contract, right? And I think what you'll find when you start to read it is that your eyes are going to glaze over and you're going to get confused. And that's what a knowledgeable lawyer is there for, right?
Yeah.
And specifically a healthcare lawyer. My biggest competition are general practitioners, other lawyers who, are business lawyers, employment lawyers, transactional lawyers, who say that, they'll represent any client, no matter what the industry is. And in a lot of cases, that's fine. But in the healthcare industry, it's a problem. Healthcare lawyers exist because they understand how healthcare laws and regulations and the source of revenue for
Mm-hmm.
their specialized business, insurance payers, um, affect those businesses both with respect to their transactions, with respect to their revenue, but
Yeah.
also with respect to their vendor agreements, their contracts. It impacts anything from employment agreements to buy-ins and buyouts and deals to these vendor agreements, right? And it's amazing how many different situations come up for these healthcare providers. They often will call different types of lawyers. They'll call an employment lawyer for an employment issue, but then they call their business lawyer, for a buy-in or because they have a vendor contract. And so they're paying different lawyers to do something that one lawyer can do for them,
Mm-hmm.
healthcare lawyer. And they just don't know that they exist often because there aren't a lot of them.
Mm-hmm.
It's not nearly as common as an employment lawyer, right? So that would be my recommendation: is find a knowledgeable
Yeah.
healthcare lawyer who can help you, and they'll help you do this, the vendor agreements, and they'll help you do everything else because that's
Yeah.
that's their role, is to serve as outside counsel.
Yeah, and I imagine 9 point something out of every 10 general business attorneys, when asked, can you help me with this breach of contract with my billing company, will say, yes, I can.
Yeah.
When maybe they ought to say, well, a little out of my I want to emphasize this, and I've said this in a few episodes before to our listeners. You are a specialist in a specialist industry. The specialist knowledge matters. It matters certainly in law. I will obviously argue that it matters in marketing, it matters in accounting, it matters in a lot of things, because you said it, the source of revenue is different. You're not just swiping credit cards and taking cash. It's more complicated to collect your revenue,
Right.
right? And there's legal agreements that govern that. It's just so different, that go find yourself a good healthcare attorney. Just Google healthcare attorneys near me. Start simple. Ask around. Ask your friends at your next
Right.
association dinner, whatever. Um, that's the one point. The second point is, EJ said it. You can start to read that contract, but better to have an attorney review it. And there's probably a few of you saying, oh my God, that's going to be so expensive. It is true that money's definitely going to go out the door to pay the attorney to do that. But I'll tell you what, if something bad happens, whatever fees you just paid to review a contract, which
Right.
they've reviewed hundreds of times before, will be eaten up and surpassed very fast as you go to
Very
fight this
quickly.
thing that could have been avoided in the first place.
Or the
Vote
losses
as
you've incurred,
what's
right?
that?
That are just not, or the losses you've incurred that are just not recoverable.
then there's that, right? So whether you're gonna
Yeah.
fight it down the road or you got to eat the losses and you're gonna be banging your head against the wall because they didn't fulfill their service, but you had to pay it anyway. All these things that EJ just shock the crap out of us about that it seems to happen all the time, but it works. View it as an investment. Beef up your cyber, yes. I just beefed up mine not too long ago. Did I like it? No. But all I need is one bad problem, which I hope never happens. And I take great pains to make sure it does. But if it does anyway, um, covered better. And I will thank God that I did it because it'll be in place. So don't view it as a cost in isolation. Go to a specialist. You'll be better off. So, EJ, thank you for coming on Practice Care. Some of the legal episodes we've done, I think, are the most interesting because you hear these sad stories. And I just say sad like it shouldn't be that way. I sell you a service to fulfill service, to fulfill service X. I screw it up all the time, but it's not my fault. Oh my God, and who would think that? Nobody, but they're written into contracts. So thanks for coming on Practice Care and opening our eyes once again to this.
My pleasure, Carl.
Yeah, and you supplied some contact information for this episode, so we're going to put that into the show notes for the episode. Anyone who wants to get a hold of you now has another way to do so. Couple of points before I wrap up, same points that I always give. First, if you are someone like EJ or us and you serve private practice owners and you've got some expertise that you want to provide to private practice owners, or if you're a private practice owner yourself, you've picked up something cool on the business side you think your colleagues would benefit from, we want you to come on Practice Care and tell the world about it. In the show notes for EJ's episode and every episode, there's a link, couple of clicks, super simple. Tell us what's on your mind so we can get you scheduled as soon as possible. And finally, Practice Care is everywhere. We're on Apple, we're on Spotify, we're on Amazon, we're on YouTube. We're super easy to find. Whatever player you use, you can find Practice Care. One word, Practice Care. Search for us, subscribe. That way you can stay up to date on new episodes. Thanks very much, and until next time.